Lordship,
Yes.
in the matter, Ms. Odek, I appear for the third and fourth respondents. Mr. Malala appears for the first respondent.
I'm present a lot in both 1 and 2 for the first respondent. I also wish to acknowledge the presence of my client in court today, Senator Cleophas.
Ms. Olicelli is present holding brief for Mr. Udoto and Mr. Okach, who represent the petitioners in both petitions 1 and 2. Ms. Mahobe was holding brief for Ashitiva. She's not present. Today she's not present.
Yes.
Could I proceed?
You kept where? So,
Oh, sorry.
yes.
Yesterday we got direction. I was not present in court. That today the court was going to render ruling on the issue of gazettement. I immediately raised the issue with IBC, and there is information which I would want to share with the court before that ruling is rendered. That information, my lord, is that there is no order that has been previously served on IBC to bar IBC from forwarding the names of the candidates for the position of for the gubernatorial position for Kakamega County. There is no order that had been served. With the result, my lord, that I'm informed that all the names that were received by IBC were forwarded to the government printers. The gazettement was to be done today. However, due to factors beyond control of IBC, particularly the hearing of the dispute nominations that have been ongoing, the gazettement is now going to be done early next week. And I was advised that the effect, my lord, of any order that would be barring gazettement, considering the time, would have a net effect of interfering with the gazettement of all the candidates for the position of Kakamega gubernatorial position. All the other candidates who are not even present in court. I'm also instructed, my lord, to inform court that the printing of the ballot papers is to commence on the 30th of this month. And the printing of papers, my lord, is informed by the gazette notice that is forwarded to the government printers, as the names of candidates as they appear on the gazette notice is transpolated to the ballots. I'm also advised that it would be prudent and neat that gazette gazettement is allowed to proceed as is scheduled, and if there is any issue, it is easier to strike out the name of a candidate than to stop the entire process of gazettement for all the candidates who are not even present in court today. Any other order, my lord, would mean gazettement that is scheduled to come out early next week will be delayed for the entire country for the reason that the Gazette notice as forwarded to government printers contains the names of all the candidates. If a recall is to be made, the government printers must send back that entire document to IBC to then remove the names for the candidates for the gubernatorial position for Kakamega County. That is all we need.
Any person who wants to say something?
Yes, my lord, I'm informed that the order was served upon the IEBC, the sixth respondent, on 7th June 2022. Yes, and what is in court today is against the first respondent only. And once the court renders itself, the IEBC can issue an addendum. So I do not believe that the issue that council is raising is going to affect other parties. It is only about the first respondent, my lord.
May, my lord, I wish to note that there is no return of service or file. Additionally, you are on record, and council knows that, in this matter, and we are yet to see that extracted order. We are equally not served. Significantly,
or not the order was extracted and served must be properly brought before the court. Otherwise, the parties and counsel do appreciate the effect of service of court processes as crystallized in the innumerable decisions of the court in this country. Today, that question has not been properly presented before the court. It should not be the basis to tinker with the issues and schedules of the court this morning. Accordingly, I will proceed and read my ruling on the request by Mr. Malala made yesterday. I have a small decision here for the parties. I have called this ruling number 2 because I delivered one yesterday for ease of reference. And I said that the court was told that time for gazettement is due today, and it is important that the first respondent is not left behind and that excluded from participation in the election as a candidate without being seen to interfere with his rights under Article 38. Two rights stand out for consideration and balancing the effect. The right of the petitioner to question whether the candidature of the first respondent sits in consonance with the law and the rights of the first respondent to contest the desired position. The duty of the court is to strike a balance between those two competing rights by ensuring that the first respondent is not prejudiced or his rights curtailed on the undetermined allegations, while the petitioners get their day in court in a quest that can only be seen to seek observance and adherence to the law. I consider it a grave matter to tinker with the rights under Article 38, and therefore I have posed to myself the question whether the need to gazette the names of the candidates for the elections of the 9th of August 2022 is cast in stone by some constitutional or statutory provisions. I have also posed to myself the question whether a decree by the court, even if made after the timeline set for today, deserve observance and obedience by the sixth respondent. In seeking to answer the first questions, I've been unable to lay my hands on any provision of the Constitution, statute, or the regulations that set date to be not less than the 25th day before the election date. That it is not in the law does not make the timelines less important, for it is appreciated that preparation for elections is not just difficult and grueling, but equally important to give the process and the exercise the legitimacy and public acceptance it deserves. However, the court appreciates that this is not the only matter that continues to pend in court, and which the court is duty-bound to determine in the shortest and timeliest manner possible to give room for the sixth respondent to properly execute his constitutional mandate. I do find and hold that the timelines for gazettement has been left for the determination of the sixth respondent to give it latitude in navigating the process in a manner that is facilitative to its mandate as the executor. It is therefore a date that can be manipulated by the sixth respondent as part of its duty to meet the obligations under Article 11 of Article 10 of the Constitution. Gazettement of nominated candidates is governed by Regulation 51, Sub-Regulation 5 of the Elections in bracket General Regulations, made pursuant to Section 109 of the Elections Act. It stipulates, Sub-Regulation 5, upon receipt of the certificate under Sub-Regulation 1 and 2, the Commission shall publish a notice in the Gazette, and where two or more certificates are received at substantially the same time, such notice shall be composite one. End of quote. A reading of the regulation leave no doubt that it is for the notification and information of the public of those certified to participate in the elections and sets no timelines. Consequently, and the court having appreciated the duty to deal with this matter in an expeditious manner, it discerns no valid reason to revisit the orders on gazettement. It reassures the parties that with their confirmation and commitment, the petition can determine not later than 29th of June 2022. The request is therefore declined. Let parties comply with the directions of the court on 23rd of June 2022 and attend court for hearing of the matter as scheduled on the 27th of June 2022 at 2:30 p.m.
Most obliged, my lord.
Yes, madam?
My lord, for the first respondent, I wish once more to request that will be provided with a certified copy of your ruling number 1 and number 2, and also given the sensitivity and weight of this matter, that with the avail type proceedings in this matter, we can also request that, given that it's a Friday, that this file be returned to the registry for our perusal and any further action. We shall abide by the court's directions with regard to petition 1 and 2 as issued by the court yesterday.
Do we take it back before typing, or we take it after typing? Which one takes precedence?
I was assuming that we've been typing as we've been going along.
No.
Because the first respondent has the right of appeal, which has to be honored also,
Yes.
and not delayed.
I'll strive and give you the 2 rulings before 1 today.
Very well.
Yes.
Very well.
I can't assure you of the typing, though. But you'll have the file allocated for typing.
Okay. Very
Yes.
well, my lord.
My Lord, we do have instructions that when directions were being given yesterday, there was some miscommunication, and I'll be praying for a review of the directions that were issued yesterday for reasons that counsel who was holding it yesterday was under impression that responses had been served upon the petitioners. However, that is not the position. They are yet to be served with the response. So it is impossible for the petitioners to do the submissions by today as directed, minus the response of the respondents. So we were kindly praying that the respondents do serve the petitioners with their responses, and if need be, we file supplementary affidavits, and then we can highlight the same on Tuesday. I would not have a problem giving 1 day to do the submissions to Monday.
So long as you file your submissions, you don't care what others are going to face, is it?
They can be given time.
And therefore, what becomes of my view that we need to deal with them the first? You know, Oluche,
Yes.
it is not for me, it is for all of us. It is for all of us. Some of us are very eager to vote, and we can't take that away from them. I am mouthy. So yesterday, I asked the person who was holding your brief, and she told me she's comfortable. It is not a new matter for me to review. I asked the council, I hope I'm not mistaken.
Yes, sir.
I asked the council whether she's comfortable, and she told